Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 15 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us in our very first episode of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane. Today's episode will cover the precedential cases issued by the Pennsylvania Superior Court, the Pennsylvania Commonwealth Court, and the Pennsylvania Supreme Court between June 17th and June 24th, 2020. We'll start with the area of criminal law. In the case of Gass versus Lebanon County, the Supreme Court ruled that probation cannot prohibit a person with a medical marijuana card from using their legally prescribed medical marijuana. Prior to this decision, Lebanon County had been prohibiting the use of medical marijuana by all probationers, even those with valid medical marijuana cards. The petitioners, along with the ACLU, challenged this practice, seeking injunctive relief and allowing them to use their legally prescribed medical marijuana. The court ruled that while a probation office may make inquiries as to whether or not the individual is using their medical marijuana for a proper medical reason, and the court may still have revocation hearings for those that are found to be using medical marijuana improperly or unlawfully, they cannot blanket prohibit lawful users from using their medical marijuana simply because they are on probation. In the case of Commonwealth v. Bright, the court looked to determine if the trial court was correct in denying the defendant the disclosure of confidential informant that was used against him at trial. The court ruled that in order for a confidential informant's identity to be disclosed, the defendant must show that disclosure is reasonable and that the information sought through the disclosure is material to the defense. Ultimately, the defendant must show that there is a reasonable possibility that the informant's testimony would exonerate him or her. In Bright's case, the court held that the trial court was correct in not allowing the disclosure of the identity of the confidential informant because Bright did not offer a proper explanation to the court on how the confidential informant's testimony would have aided in his defense. In the final criminal case, Commonwealth v. Starr, the case involved the sentence of a man who was convicted of crimes involving statutory sexual assault and crimes against minors. In this case, he asked the court to review a part of his probation period of his sentence. He claimed that this probationary restriction impaired his ability to function in modern society and that the restriction is not tailored to meet his specific rehabilitative needs. The condition in question was that he was not to have access to the internet. The court held that his sentence was proper because the restriction on the internet condition was based on an individualized assessment on him by the trial judge who imposed the sentence. In his second claim, Starr questioned the constitutionality of his sentence in total, in which the court held that the question of his sentence was ultimately based on the discretionary aspects in which he did not preserve this issue during his appeal process. The next area we're going to get into is education law. In the case of Easton Area School District versus Rudy Miller and the Express Times, the case analyzed the right to know law and FERPA to determine if a video from a school bus surveillance camera is protected from disclosure under the law. The video alleged that an elementary school teacher had an incident that included physical discipline of a student while on a bus, and the video was requested by Miller, who works at the Express Times. The request for the video was originally denied by the school district, and the district claimed that the video was exempt under the right to know law, which exempts from disclosure a record which would result in the loss of federal or state funds by an agency or the Commonwealth. Miller then appealed the district's denial of his request to the Office of Open Records. The Office of Open Records allowed for the disclosure of the video. The school district then appealed to the Commonwealth Court and argued that the video constituted an educational record. The Commonwealth Court agreed with the trial court and said that the video is not an educational record for the purposes of the Privacy Act and that the disclosure of the video would not subject the school district to loss of federal funding. The Supreme Court of Pennsylvania then granted aliquotter. The Supreme Court held that the students' images in the bus surveillance video are exempt from disclosure under FERPA and its regulations and are thereby excluded from the right to know law disclosure requirements pertaining to public records. However, insofar as the students' images can be redacted to remove their personally identifiable information, the video itself is not exempt and therefore must be disclosed. In the case of Hazleton Area School District versus Central Columbia School District, the court analyzed a dispute between two school districts on whether or not one district who allows a student from another district to attend for a VOTEC program is entitled to reimbursement of tuition from the student's resident school district. The court held that a school district is entitled to reimbursement if a student from another district attends their school district for a VOTEC program, if the student is taking the VOTEC program and general studies classes. The court held that the district that the student is attending must confirm the eligibility of the student and properly enroll them within their school district in order to receive reimbursement from the district in which the student resides. We'll be right back with you after a quick check-in with our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back. Now we're jumping into the area of employment law. In the case of Mirsada Begovic versus Unemployment Compensation Board of Review, the claimant initially filed for unemployment in February of 2018. At that time, she was ineligible because she did not meet the minimum wages in the base year. In determining her eligibility, they did not include the wages she earned while working for companies such as Open Pittsburgh or Steel City Interpreters. She appealed, and after a hearing, it was determined that even though she can be seen as an independent contractor, she did not fit the mold to be considered a self-employed business person, but she was eligible for unemployment compensation. Open Pittsburgh and Steel City's interpreters then appealed. The court went through both employers and the claimant's time with each employer. The court found that the claimant is categorized as self-employed and therefore not eligible for employment compensation. The court reversed the decision of the Unemployment Compensation Review Board, ultimately holding that in order to meet independent contractor status for purposes of unemployment, both prongs of Section 4L2B must be met. Section 4L2B provides in pertinent part that services performed by an individual for wages shall be deemed to be employment subject to this act unless and until it is shown to the satisfaction of the local service center that A, such individual has been and will continue to be free from control or direction over the performance of such services, both under his contract of service and in fact, and B, as to such services, such individual is customarily engaged in an independently established trade, occupation, profession, or business. In this case, the court held that both prongs were not met for the claimant's employment with Open Pittsburgh or Steel City Interpreters, and therefore claimant was not eligible for unemployment benefits. Next, in the area of Post-Conviction Relief Act cases. In the case of Commonwealth versus Anderson, Anderson filed a Post-Conviction Relief Act, or PCRA petition, approximately 4 years after his judgment became final on the underlying case. The PCRA was dismissed as untimely. The general rule in Pennsylvania requires a PCRA petition to be filed within 1 year of the date the judgment becomes final, unless one of 3 statutory exceptions applies. Part of Anderson's sentence included lifetime registration as a sexual offender. Following his sentence, the court decided the Muniz case, which held that the lifetime registration requirement is unconstitutional. Anderson argued that due to the decision in the Muniz case, his sentence was also unconstitutional, and therefore his PCRA case petition would meet the constitutional right exception. The court in Anderson found that the PCRA did not meet the exception to the 1-year PCRA time bar because the Supreme Court had not ruled that the Muniz case applied retroactively. In the case of Commonwealth v. Tyler, the court affirmed the trial court's decision to deny Tyler his request for testing of new DNA evidence. The court first addressed the topic of PCRA petitions and DNA requests, in which the court held that a PCRA petition is separate from a request for DNA tests, and therefore they do not preclude one another. Ultimately, the court denied his request based on the theory of accomplice liability, as well as the existence of conspiracy, and that the testing of DNA evidence would not show innocence. The court also stated that within his motion, Tyler did not put forth any additional theories, circumstances, or evidence that, taken in combination of the absence of his DNA under the victim's fingernails, would establish that no reasonable juror would have found him guilty beyond a reasonable doubt. The last area we're going to address today is property law. First, in the case of SDO Fund versus Donahue. This case arose over a dispute over the judgment on a property and analyzes the use of a warranty of attorney for a judgment on said property. In this particular case, the warrant of attorney and confession of judgment was exercised on several occasions prior to the instant case. The general rule in Pennsylvania is that a warrant of attorney to confess judgment may not be exercised twice for the same debt, though under certain circumstances and to certain extents, parties to a note may waive this rule, allowing for multiple exercises of a warrant of authority or attorney to confess judgment. In this case, the court said Donahue executed multiple agreements that ratified and confirmed the confession of judgment provision contained in the original guarantee. In essence, the parties, through their own contracts, agreed to allow for multiple exercises of the warranty of attorney to confess judgment, which is plainly permissible. And finally, in the case of Deschert LLP versus the Pennsylvania Department of Community and Economic Development, the court analyzes a case taking place in Philadelphia dealing with properties in the KOZ zones. In these zones, businesses get certain property tax benefits that are highly desirable, but they only last for 15 years. Deschert was located in one of these zones for 15 years until the zone expired in 2018. At that time, Deschert decided to move and sign a lease for 100,000 square foot in a new zone, but decided to check with the DCED, which is the administrative board governing the issue. The DCED ruled that if they did this, they would not be eligible for tax benefits at the new KOZ zone. There was an appeal, and the court sided with Deschert because in applying the rules of statutory construction that constrain them to reading into the plain meaning of the statute, they found that the relevant provision of the KOZ Act did not prohibit this kind of move. It did prohibit moving from one zone to another, but the fact was that now the area they were located was no longer even a KOZ zone. This freed up their movement and allowed them to receive benefits at the new location. Therefore, the DCED overstepped its authority in denying Deschert's request. Thanks again for tuning in with us this week. Join us every week to make sure you stay in the know when it comes to Pennsylvania case law updates.
Thank you for listening to Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in old-fashioned central Pennsylvania values of hard work and straight talking. Give them a call if you or a loved one ever needs help.